workshop 5. Human rights, dignity, and belonging. And if I didn't see you yesterday, my name is Farida. And our first speaker is Nelson Otieno, Okeyo. And Nelson is a technology lawyer and an advocate of the High Court of Kenya. And he holds an LLB from Kenyatta University, a postgraduate diploma from the Kenya School of Law. Oh my goodness, a lot of qualifications. And an LLM from the University of Dar es Salaam. And he is currently pursuing a PhD at the University of Bayreuth under the International Doctoral Program. And he's doing business in human rights. His research is focused on data governance, regulatory compliance, human rights, and data justice. And he's going to be speaking to us on his topic, evolving the role of law, role of courts even, as a beacon of navigating challenges of belonging in context of digital identity. And I'm sure by the end of that, we'll all be much enlightened. So thank you very much, Nelson. Over to you.
Thank you so much. Just to let me know how much I'm going to.
On your marks, get set, go, 15 minutes.
Okay, perfect. So
16 past.
okay, perfect. Thank you so much to the Chair of Legal Studies for organizing the PhD workshop, and that is also part of the celebration conference that we are having. And also thank you for coming to listen to us. Looking forward to making this presentation and also listening to what my colleagues who are now very well known to me will also be saying. I'll hope that at the end of the presentation that I make, I shall generate or let you know about an outlook of a paper I intend to present at the end of as an output, and I hope that I shall arouse your interest enough to solicit feedback that will also go a long way in making sure that it is of quality. Just to let us know that you'll be seeing a case that I'll be referring to, which is a case that was decided in a case filed by Haki na Sheria. So Haki na Sheria is a Swahili word meaning justice and law. Usually most of the journals that I read are all law and justice, so there's always a lot of presumption of justice, law forming the foundation of justice. But Haki na Sheria is an organization that has really done a lot of work on the protection of marginalized populations. It would really be nice to highlight and to let us know what learnings about belonging that we can find about in terms of the litigation experience from the case that was filed. So just to give us an outlook that will let us know about what problem led to the case to be filed, look a little bit of the litigation history, and I'll be trying to give us some outlook, give us an outlook on some of the critical issues on belonging that arose from this case, and also let us know what learnings I'll be looking for. So most of the discussion, some of them will be very futuristic, so I'll be letting you know what is in my mind or what I intend to put in this document. So foremost, this will be on something on nationality rights, and the right to nationality is provided for in the Universal Declaration on Human Rights, and Article 15 states what this right should be in terms of stating what the duty of states should be: to register citizens and also to issue them with documents that recognize their status within the country. So this is expressly provided, and of course the examples that states can give The examples that states can have include, giving national ID cards, passports, birth certificates, and the rest. If you look at the distinction, and you'll see what the topic I decided to speak about. If you look at the distinction, there's a very clear distinction between a citizen and a non-citizen, and for the purpose of the discussion, a refugee. And a citizen has certain rights, privileges, and entitlements, including right to own, to take part in the public discourse through voting and or standing for or to be elected to a public office. Very important aspects of a person's belonging to a nation state. So this is very important. The reason why I thought of writing this way, that way, no in between, will become clear as we speak. But just to let us know, why did I have to choose to discuss a case at a conference that talks about law and belonging? And we've had instances of a lot of failures by courts in their analysis of law, at least from the presentations that we had yesterday. I usually am not a big fan of the obsession with new laws. So whenever we go to conferences or events, the obsession that there's a new issue that needs to be addressed by law, and that we now need a new law, I'm not usually a fan of that, because I believe that is usually the very path that leads us into the trap that we are trying to avoid. It creates what I call a phenomenon of legal filibustering, which then states and businesses use in the assumption that there's a supposed lacuna in the law, and to try to use this to abuse the very principles of law that are provided for in the Constitution. This is what has inspired my view, and you'll shortly see why I talk about this. I'll be briefly talking about this because I believe that there are legacy laws that can be repurposed and reconfigured to address problems. And this will just let you know some of the 3 key learnings we can get from the case that was decided, to see how the court applied principles that can help us shape the discourse of belonging in trying to address some of the stark realities of marginalization that arise as far as nationality is concerned. So I take you back to my university LLB time. I have this friend of mine from north eastern part of Kenya, where we have counties such as Wajir and Garissa. And he tells me from the stories that when they go to Nairobi, which is the capital, they say that we are going to Kenya. We are going to Kenya. They say, tunaenda Kenya, meaning they are going to Kenya. But jurisdiction-wise, if you look at the national borders, they are within the country called Kenya. And one of the candidates for election to the national elections body, when it was being interviewed recently, he said one of the major things that happened in their life was devolution, because through that, they consider that independence from Kenya. So we have people living in Kenya, but for some reason, because of nationality issues, they think that they're not in Kenya. Now, what happened in this case was that there are communities that live in the northeastern part, some children and women mostly who live around refugee camps, because of certain reasons that I will explain to you, have chose to be registered as refugees. They chose to be registered as refugees. The reason, and you shall see in the highlight, the major reason for this were 3. One is desperation. Desperation. Number 2, vulnerability. And number 3, ignorance. Now, these are the reasons why they registered. When I was doing the case analysis, I also realized that there was some tinge of patriarchal system of the societies, the communities in the north, because most of the registrations were being done on behalf of the children by their uncles, and some of these registrations were also being done by women who were divorced And so you find a divorced mother of one having to go to be registered in the database as a refugee. And as a result, the children born and registered as refugees having a problem when they turn 18 because they get themselves into a situation of double registration. This has been a serious problem in Kenya. And as I've mentioned, it is a double registration problem because then a Kenyan citizen is not able to be registered as, is not being able to be registered as a citizen because their citizenship was by birth, but because of the double registration system, this brings a challenge. And as you can see, this is an issue which brings a lot of problems. One is the direct impact that they're not having access to nationality. Number two is that they are not able to have access to the rights that come through nationality. And number three, the more interconnected effect that with the introduction of digital ID system, it means that they cannot be able to register to be part of the digital ID system on which 17 public services are hinged. So that can tell you the depth of such exclusion. Now, in terms of the court, what happened in court, these communities were represented by Haki na Sheria in court. They litigated the matter, but there was one of the contentious issues which was done by the court, and afterwards there was a determination. And allow me just to take us through some of the main decisions that were made. And I think that this decision that was made by court is one of the cases that can help us to shape the discourse of belonging. And for me, from where I sit, it is a success case of how courts can play the role of what happened with the widow from Zarephath, at least for those who have learned about the widow who was asked, what do you have in the house? Because Professor Elijah had to do some multiplication. Sometimes we have to ask ourselves, courts in their role to develop the law have to ask themselves, what principles do we have without the fascination of having to adopt the law to try to see what new ways can they use the old law to try to address some of these evolving problems. And let me highlight them. Number one, the court adopted what I call the hierarchical rights approach to nationality, and which I will also say to belong. Yesterday, our colleague mentioned about stages. There were discussions as to whether we need to consider this as part of perspectives. I will also recognize that maybe we also need to start thinking about hierarchy, because the court, in making the determination, say that nationality is a very vital aspect of a person's life. And in so doing, it is like the master key to the right system. So imagine that all rights are in this house and you have a master key and you're outside. You only have the nationality as the master key. It means if you lose it, if it is not easily, you can't easily replicate it. If you lose it, then you have lost all your rights. This, in my view, is a very good approach that can also help us to try to shape narratives and to try to think, should we be looking at belongings, and maybe are there opportunities when we look at belonging as one of the rights as an entry point for belonging. And I'll give an example from a strategy point of view as I'll be finalizing. If the court, if the petitioners who took the matter to court went and sued the schools, why the schools are not accepting their children, or if they went and sued the hospitals, if they went and sued the institutions that are violating the rights that are in the house, they will not be dealing with the main problem. The court adopted a gateway approach, saying, as we analyze belonging, as a matter of strategy, and especially for CSOs, they need to be looking at what is the gateway for belonging. For this will be a very good strategy for prosecuting such matters. I will also be talking about the non-culpability, and what the court said is this. The government was saying, if you go and register yourself as a refugee, then you are an author of your own misfortune, which in the legal sense makes a lot of sense, because ignorance of law is no defense. And if you look at the fact that you need to do due diligence and the fact that they admitted to this, but the court went and said that the fact that they are registering out of vulnerability and out of vulnerability and ignorance means that their registration is inevitable. In other words, the court was taking a victim-centered approach in terms of making a determination. I will be trying to discuss some of these issues, how they will be able to have implications on understanding belonging, because those to whom we belong might also create laws that can cause non-belongingness. So how does this then shape the discourse of belonging, and especially from the context of what I call the non-culpability approach? And lastly, I'll also be looking at the proactive state responsibility approach, which the court take. In my view, the court was doing what only Human Rights Council, you can only do or in the ordinary cases where they go on to say, this is what the Article 15 of the UDHR should mean. But they went on and say, if you're a state, and you have not provided people the food and necessary requirements for life, and as a result, they do something and find themselves in the refugee database, you have violated your obligation. A very innovative approach of reading into the law what is not there, but I believe that some of these approaches can help us to try to imagine what belonging could be in the discourses that we shall be having in the times that are lying ahead of us in future, especially in the context of marginality of populations. Thank you so much.
Thank you very much, Nelson. Appreciate it. Sorry. Thank you very much, Nelson. Appreciate it. Thank you for keeping to time. Next, we're going to have Gift Gawanani Mauluka. And I don't know that we need to introduce Gift. If you don't know Gift, basically your life is not worth living. That said, for those of you who are online and don't know Gift, you're lost, but here we go. Gift is a PhD candidate at the Chair of African Legal Studies. He's working as a research assistant here in the cluster on intractable human rights problems. His research interests are children's rights and gender equality, well done you, and climate change. He's currently working on a research project interrogating the disparity between comprehensive legal frameworks on child labor and the increased cases of child labor in Malawi, and whose work employs socio-legal research methods and unorthodox approaches to understanding human rights problems. I like the unorthodox. I look forward to hearing more.
Thank you so much. I really appreciate what you have said about knowing me. Very humble for that. I would like to thank the organizers of this workshop for giving me a chance and accepting my abstract to be presented. They had a chance of denying it, but thank you for that. And I should point out that this is work in progress. I'm trying to gather my thoughts around what is troubling me at the moment. And what I'm presenting is from my experience. I've worked with a women's rights organization in Malawi. I've worked with a child rights network in Malawi. So what I'm writing is from what I've got from my experience with that. So I'm saying we are tackling domestic violence in borrowed robes. These borrowed robes are, in my perception, the laws that are governing Malawi's legal framework, specifically to do with child labor and women's rights. Saying Malawi's legal system has its roots deep embedded in English common law, a legacy inherited from British colonial law. This framework continues to underpin Malawi's constitution, legal institutions, and procedural mechanisms, shaping the contemporary judicial landscape. Malawi was colonized by the British, by the way. However, this inherited system raises critical questions about how well these transplanted laws, according to Watson, aligns with Malawi's unique social, cultural, and socio-economic realities, especially regarding protection of women and children. What I'm claiming is that there is a persistence of colonial rules in Malawi's legislation. For example, if you look at the Penal Code, it criminalizes same-sex marriages. That is a borrowed concept from what the English law talks about. When Malawi gained independence, the Malawi Law Commission was tasked to look at some of the laws that have got these tendencies. But surprisingly enough, when they were reviewing this particular section, it was mainly to do with men having relations with men. What the commission did was to say that it was discriminatory and just introduced that females also have to be included in the provision, not to look at the contextual issues and maybe make it better in a way. Another example, the Malawi National Examination Board, which regulates the examination of students at primary and secondary school level, for one to be certified as completed their Malawi education level, they have to pass at least with 6 credits. Out of all those 6 credits, if you don't pass English, you don't get certified. For an agro-based country, maybe passing agriculture should have been mandatory in a way. That could reflect what is there on the ground. So this raises critical questions whether these outdated laws adequately address the lived realities and evolving cultural norms of the Malawian society. So what's happening is that the judicial reliance on legal registration provisions, there is no critical analysis of the lived realities on the ground as one might want to say. Ishikawa, in his writing about the Malawi legal system, he says that the Malawi courts predominantly focus on citing existing legislations instead of critically examining how inherited legal principles harmonize the constitutional socioeconomic rights. In saying that the judges have got a chance to question these laws. And when they question, they should be able to look at the lived realities of the communities and embed them in their judgments. But this, according to him, seems to be lacking. As a result, such an approach may overlook the nuanced socioeconomic contexts that affect the application of laws, particularly in matters concerning vulnerable groups, which include children and women. This also has got an implication on justice accessibility because the nuanced ideas, the things that are happening on the ground are not taken into consideration. People might feel like they are being left out. The governance structures that are there are also in a way as an inheritance from the colonial systems that are there. With this, there is a loss of trust by the communities because the communities look at this as not a reflection of what is there and what is happening on the ground. So the protection, occupation, and tenancy orders, which are in the Prevention of Domestic Violence Act, is the example of what I would want to reflect how this colonial legacy has been perpetuated on the ground and moving forward. But then in the Domestic Violence Act, there are 3 specific orders. The protection order, this order is aimed at providing immediate safety to victims of domestic violence. For example, if a woman or a man is experiencing violence against violence in the home, they are mandated, they have got the right to go to the court and ask that they be protected from this act of violence. And the court might order the perpetrators to refrain from doing something, refrain from acting in a particular way. There is also an occupation order which grants the prescribed person named in the order the right to leave the household residence, to leave those that they are living in the household so that the violent acts should not perpetuate anymore. There is also a tenancy order, which the order vesting in the applicant the tenancy of any dwelling house. So if I'm living in a house, in a Malawian context, in a rented house, the order can order me to leave this household, but continue paying rent when the people that I'm violating are still living in the house. But then the contextual challenges which comes with this is that if I'm living in a rented house, and I've been taught to continue paying rent for this house, the probability of me continuing doing that is very negligible, considering the Malawian society. And in a society where it may be in a matrilineal society, where I am required to live amongst my wife's relatives, and an occupation order has been granted, that means I'll be living amongst the people that are not directly related to me, but they are directly related to my wife. Then the contextual challenges that come with this is that if we are to use these orders, there is a discrepancy between what the communities think of the laws and what the laws provide as solutions to that. So the socioeconomic factors that has also to be considered are that if I'm taken out of this household and government doesn't provide the safety nets for the children and my family living in this household, how are they going to maintain their livelihood when there is nothing that can support them? So the holes that I'm punching into these provisions based on the traditional family structures of the Malawian society, the legal disconnect that is there, that in my mind has not been considered, and the socioeconomic factors. What I think might be the conclusions, which I would have to bounce off some colleagues to see whether they work or not, is that there has to be a recognition of the colonial legacy that is there in understanding how the historical and legal framework shapes the current governance and justice systems. If this is not recognized, we'll continue reinventing the wheel and facing the problems that I have highlighted. There is also need to contextualize the law to look at adapt legal provisions for better reflect Malawi's cultural and socioeconomic realities. The other thing is to strengthen community engagement, knowing that the community owes it to each other to live in harmony away from this away from this violence. Maybe another strategy would be to bank in the trust that the communities have with each other. And there has also to be an enhanced judicial analysis that encourages courts to integrate socioeconomic rights with legislative provisions for a holistic justice delivery. If I still have got time,
You have a minute or two, yes.
in that meaning,
I've got 5 minutes, I think.
I'm saying that robes rob us, and the gowns ground us. We are robbed and grounded when their owners are long gone, leaving us chained to their gowns. Our systems smeared with doubt, our institutions disintrusted, our oneness and confidence in ourselves rusted. Yet they are forever gone, and we feel we don't belong. And maybe their gowns and robes don't belong, but it is not wrong to long. Maybe I've spoken for long. Probably I've coined these lines so long and wrong, but at least that's how I feel I belong. Because these lines are not borrowed robes, as borrowed robes rob us. If these robes and gowns are gone, maybe we'll feel unclothed, but if it's better unclothed among our own, because we won't feel alone and robbed. That's how I feel I belong in this place. Thank you so much.
That's extraordinary. Thank you. In Shona, we say Waroa Gungumkano. you've hit the baboon in the mouth, meaning you've captured all my passions with such a fabulous, fabulous talk, and yours too, by the way. So thank you very much. You guys are really being spoiled today in our last session before the great King Chepo comes. Clothes are in rubber. Okay, I'm going to stop messing, I promise. Right, Sebastian Krafzik. I think you're online. Yeah. See, I'm turning German already.
Right, good afternoon.
You're South African.
Right,
Hello.
good afternoon.
Hello, Sebastian. So Sebastian Krafzik is a postdoctoral, Dr. Krafzik is a postdoctoral fellow in banking and financial law at the University of Cape Town, focusing on ethics, sustainability, and the regulation of global financial markets. He studied law and economics at Goethe University in Frankfurt and has practiced law in investor protection and proxy advising. Sebastian earned his doctorate with high honors from University of Basel on board accountability and corporate governance. He has taught and contributed to research at institutions such as Leuven, Sorbonne, UCL, University of Kigali, and the Catholic University of Malawi. And so he's going to be speaking to us about the World Bank's legal framework and economic belonging in Africa, development, dependency, and exclusion. So thanks very much, Dr. Krafzik, and over to you.
Thank you very much. Let me just try to share my presentation. I have sent a request. Here we are. Documents. Just give me one more second, please. Here we go. Are you able to see my PowerPoint?
Yes.
Sure. Thank you.
Thank you.
Cool. All right. Good afternoon. Thank you for this kind introduction. Good afternoon from Cape Town, and warm greetings to everyone gathered in Bayreuth, dear colleagues and guests. It's a pleasure to join you virtually to discuss how the legal frameworks of the World Bank shape economic belonging in Africa. This is not just a question of finance, it's a question of power, sovereignty, and justice. My argument today is simple. World Bank's legal and governance architecture was never designed for Africa, and its current model reinforces a system of dependency and exclusion. Let us begin by placing the World Bank within the larger framework of global economic governance. Often seen as neutral technical institution, a financer for the global south, the bank is in fact a powerful and legal actor. Through its governance structure, financing agreements, and policy conditionalities, it reshapes national priorities and constrains domestic policy space. This raises key questions. Whose development model is being promoted? Who writes the rules? And who ultimately benefits? To understand how the World Bank shapes economic belonging, we must examine first its governance, a structure that embeds legalized inequality and dependency. The bank operates a two-tier system. At the top level is the Board of Governors, which consists of one governor from each of the bank's 189 member countries. Voting, however, is weighted by financial contribution, not equality meaning. The United States holds over 15% of voting power, Japan, Germany, the United Kingdom, and France also hold large blocks. All sub-Saharan African countries combined control less than 7% of the vote. This means a handful of wealthy countries can overrule the entire African continent, even on decisions that directly impact it. Yet, the board meets only once a year and only approves major policy decisions, such as new membership and capital increases. Real power lies with the board of executive directors. This board handles daily decisions such as lending terms, legal reforms, project approvals. The board comprises 25 executive directors, each representing either a single country or a constituency, which is a group of countries with shared representation. Critically, both representation and voting power are not based on sovereign equality, but on financial contribution, reinforcing a deeply hierarchical structure. 6 of the 25 seats are occupied by single country representatives from the largest shareholders: the United States, Japan, China, Germany, France, and the United Kingdom. These countries enjoy permanent individual representation, allowing them to directly and consistently assert their policy positions, safeguard national interests, and shape institutional priorities. The US, with over 15% of total voting power, grants its de facto veto power, since major decisions require an 85% supermajority. Even informally, the largest shareholders influence staffing, agenda setting, and legal policy. By contrast, let's have a look on another screenshot from the World Bank's website. By contrast, the remaining 19 directors represent 183 countries, including 3 executive directors for all sub-Saharan Africa, as you can see on the screenshot. These directors must speak on behalf of large, diverse constituencies, often encompassing countries with conflicting priorities, divergent development needs, and varied legal systems. Legal and financial decisions, from conditionalities to reform models, are often shaped in Washington, Tokyo, or Paris, while African states implement and bear the consequences. This is not multilateralism. It is structured dependency disguised as partnership. To understand how power and benefit are distributed within the World Bank, we must also examine its capital structure. The bank separates members into Part 1 and Part 2 countries. This classification reflects a broader asymmetry. While Part 2 countries rely on loans for development, Part 1 countries do not borrow from the bank. They govern it. At first glance, this may suggest a system based on altruism, donor countries helping poorer nations through concessional finance. However, the distribution of benefits tells a more complex story. Although funding is challenged to Part 2 countries, the procurement rules attached to World Bank loans often stipulate the goods and services must be acquired through international competitive bidding. This opens the door for firms based in Part 1 countries, the donor countries, the global north countries, to win contracts, supply materials, and provide technical expertise. As a result to this, large-scale infrastructure projects, such as the construction of a dam or a transport corridor, may be financed by the World Bank on behalf of a developing country, yet it's executed almost entirely by firms from the global north. In this structure, development financing becomes a circular economy. Donor states contribute capital, set the rules, and then reap economic returns through procurement, all while borrower states assume the legal and financial obligations of debt repayment. The World Bank's power lies its binding legal instruments which reshape national policies under the banner of development. Let us consider three of the most significant. Let's first have a look to structural adjustment programs. These imposed conditions like privatization, liberalization, and fiscal retrenchment, legally requiring states to cut spending and deregulate, often at the expense of public welfare. Project financing agreements as another example. These contracts are meant to provide loans for infrastructure development to come with strict legal terms on procurement and safeguards and debt repayment. Yet, communities affected by these projects are rarely consulted, despite facing displacement and disruption. As a third example, let's talk about governance conditionalities. These push reforms in law and institutions, often transplanting foreign legal models poorly suited to local contexts. These tools are presented as reform and development. But the real question is, reform for whom? Development by whose design? These legal frameworks don't just shape policy, they override national processes. Governments may be legally bound to implement austerity or reform laws on land and labor that conflict with their own development plans. Despite language around ownership and partnership, the reality is that the bank's legal instruments often produce dependence, not autonomy. They shift decision-making power from African states to external institutions. The World Bank's frameworks often exclude the very people development is meant to help, especially those in the informal economy. Market traders, subsistence farmers, rural women. These groups are rarely featured in policy design. Liberalization policies often remove subsidies and raise prices, disproportionality harming the poor. Meanwhile, the push for formalization and commodification clashes with traditional cultural embedded systems of livelihood. The outcome is legal legislation exclusion, a development process that is technically lawful but socially unjust. Beyond economic loss, these policies cause psychological and social disruption. Displacement from infrastructure projects or loss of land rights fractures communities and erodes trust in institutions. This leads to resistance and unrest, not because of communities rejected development, but because they see that the legal framework itself excludes them. In the end, law becomes not a source of protection, but a symbol of alienation. To illustrate how the World Bank's legal and financial instruments structure economic exclusion, let's look at Malawi as one example. I prepared more examples, but I think the time only allows to have a look to one example. Malawi, where World Bank-backed reforms have deeply influenced agriculture since the 1980s. In the 1990s, the World Bank promoted liberalization of maize markets, including the removal of fertilizer subsidies and the dismantling of the Agriculture Development and Marketing Corporation, that is the State Marketing Board. This led to a major food crisis in 2002, leaving over 3 million people food insecure. Instead of reversing course, the 2006 Agriculture Development Program by the World Bank pushed further toward cash crop exports and private sector control, while failing to restore support for stable food production. The 2016 Land Act, backed by donors, shifted land ownership toward individual titling, weakening customary land rights, and marginalization smallholder farmers. Malawi shows how legal reforms designed externally in the name of market efficiency can undermine local food systems, increase vulnerability, and deepen dependency. At the heart of this analysis lies a critical hypothesis. The World Bank was never intended to address Africa's development realities. To understand this claim, we must look to the historical context in which the bank was established. Founded in 1944 at Bretton Woods, the bank's mission was to rebuild Europe after World War II. At that time, only 4 African countries were independent, namely Liberia, Egypt, Ethiopia, and the Union of South Africa. The rest of Africa, the rest of the countries were still colonies. Africa's unique challenges were simply not part of the original design. Post-independence, African states faced entirely different realities, such as balance of payments crisis, weak institutions, limited industrial capacity, and legacies of extractive colonial economies. What they needed was long-term structural support, not short-term loans tied to narrow reforms. But the World Bank's model is still based on repayable financing, risk management, and market assumptions drawn from industrialized nations. Today, African states are often criticized for not meeting benchmarks that were never suited to their contexts. Rather than adapting its model, the bank expects African countries to find into a system built for others, reinforcing cycles of dependency and underdevelopment. Where do we go from here? As the limitations of the World Bank's frameworks become clear, alternative models of development finance, like the African Development Bank or South-South frameworks such as BRICS or the UN Office for South-South Cooperation, offer potential for a more equitable African-led approach. Chief among these institutions is still the African Development Bank. The African Development Bank structure, while still reflecting a balance between donor and borrower states, gives African countries over 50% of voting power, unlike the World Bank, where donors dominate. Its decision-making bodies are more regionally representative, allowing development priorities to be shaped around African needs, such as regional trade, infrastructure, and rural livelihood. The African Development Bank has supported initiatives like the Programme for Infrastructure Development in Africa. It also engages with customary land rights and informal economies, adopting a more flexible legal pluralist approach than most global lenders. It uses advisory tools and model frameworks to co-develop legal norms with member states rather than impose them. Still, the African Development Bank is not free from external influence. It relies on non-African capital from countries like the US or the European Union countries. These donors hold substantial voting shares and can influence priorities, especially during recapitalization.
I'm sorry, I'm going to have to stop you. If you could please give us your conclusion, and then we can always come back in terms of Q&A.
Sure.
The issues.
So while more inclusive, the African Development Bank still operates within a global system that often pressures it to conform to donor expectation. In conclusion, the World Bank's legal framework remains a paradox. It is a vehicle for economic modernization, yes, but also a mechanism of dependency and exclusion. If we wish to reclaim economic belonging as a right, not a privilege, then law must serve not only markets but people, not only efficiency but dignity. The time has come to challenge the legal orthodoxy of global development and to begin reimagining frameworks of growth and justice from within the continent rather than from beyond its borders. Thank you very much.
very much for that masterclass on structural inequality. That was so clear. Very much appreciated. Thank you.
Thanks to you.
We're going to move on. And here, I wish I'd done this at Toko's a lecture last night, but I think Isabelle and Toko deserve it. So we shall ululate to celebrate. Because I think Isabelle has been one of the people, along with the crew, who's worked incredibly hard. Of course, we've celebrated for the past couple of days. And I was so relieved to see Isabelle here because I think this is the equivalent of breastfeeding. You can't walk around with the child, you have to stay still. So now that she's doing the work, doing the talk, she has to be still and to actually be able to engage with us, which is lovely. So Isabelle Zundel is a law graduate from the University of Bayreuth, so she's a home person. She also undertook her PhD project on claiming social rights through the African human rights system, analysis of normative, institutional, and procedural frameworks here at Bayreuth. And she had research days at the University of Western Cape, Dr. Leah, the University of Pretoria, and the Max Planck Institute for Law and Anthropology. And Isabelle will be speaking to us about law and belonging, social rights in Tunisia, which I've never heard about, so please.
Okay, thank you very much. Gift just wish me good luck, and I think it's unfair to present after Nelson Gift. I think it shouldn't be allowed, but I will still try. Farida, thank you very much for your kind words. I would wish to give them back because I actually haven't been that much involved. So thank you for everyone that has put in the hard work to make this conference happen. And I'm really, really glad that we have had all these conversations over the past days and that I can also contribute to that. So the title of my presentation today is This is Why I Hate My Country, SOGIESC Rights in Tunisia. And just a small reminder, so SOGIESC is the meaning for sexual orientation, gender identity, gender expression, and sex characteristics. And in the following, I will use the terms LGBTIQ+ individuals and SOGIESC rights and issues. And I have a particular emphasis on the criminalization of sexual activities between persons of the same sex that Gift also mentioned in his presentation before. So my reflections are grounded on a personal encounter I had in Tunisia some time ago. And I've been working on this paper for some time. It's not where I wanted to be, and Nelson has already given me some input, so please bear with me, and I look forward to your comments in the end to make it even better. In addition, I just wanted to mention I'm really not an expert on Tunisia. I just would like to use this hook to make some broader observations around SOGIESC rights and the connection to law and belonging. And my presentation will be structured into 4 parts. First of all, there will be a small prologue. And after that, I will say a few words about criminalization of same-sex sexual acts and Tunisia's penal code. I will then share some developments around SOGIESC rights in Tunisia, and probably I will only have time to talk about the recent developments over the last 10 to 15 years. And in the end, I would like to share some learnings and observations for law and belonging. Okay. A while ago, I traveled to Tunis, the capital city of Tunisia, for an intensive French language course. It had been years since I last studied French in secondary school and at university, and I was eager to refresh my skills in a sunnier place than Germany. Along with a friend, also from Germany, we made all the arrangements for this study trip. and made sure we booked a really nice Airbnb near the beach in La Masa, which was, by the way, a very good recommendation by Miniksha. The Airbnb was coordinated by B, who handled the day-to-day business of the apartment for her parents. Although we arrived very late on the first night due to flight delays, and B had to wait for us in the cold Tunisian winter night, we connected right away and became friends. We spent a lot of time discussing politics, society, and its unfeministic patterns, but we also just went to the movies and exchanged traditional recipes from our home countries. One day, I asked about the criminalization of same-sex sexual relations in Tunisia, a topic I had studied for years during my doctorate, and I was just in general interested. And B gave me a very precise answer, explaining that the maximum penalty for same-sex sexual activities would be 3 years in prison, according to the penal code. She ended her explanation with "c'est horrible," one of her favorite expressions, along with "c'est très bizarre." She also said that a lot. I was surprised by her explicit knowledge of this topic, but I didn't question it then. Only later did I realize why B had such a detailed response at hand. It was a daily threat she faced. On our last evening in Tunis, we planned to go to the cinema together to watch a feminist Tunisian movie, La Maison Dorée, a movie that I can really recommend. To everyone's surprise, we, the Germans, were running late. So we had to wait for the next screening. While sitting in a cafe, we started talking about love and relationships. I asked B about her past relationships and whether she believed in romantic love. She shared that she had been in a relationship before, and as she glanced over at her parents, who were sitting at another table in the same cafe, she mentioned that things had been difficult with them. I did not understand what she meant, but it was clear that she did not want to share more, so the conversation just continued. After a few minutes, B confided in us that she had been in a relationship with a woman for 11 years, her best friend. The cafe was bustling and noisy, with football and music videos playing at the same time. But at that moment, everything fell silent. These stories seemed to absorb all the noise in the room. She explained that it was a heartbreaking situation because they had broken up. The distance created by their careers abroad had taken its toll. But most importantly, their families, each practicing the Muslim faith to different extents, would never accept their love. So she ended by saying, "This is why I hate my country." So, to B's best knowledge, Tunisia, like several other countries, criminalizes same-sex sexual activities between both men and women under Article 230 of the Tunisian Penal Code, with penalties, as mentioned before, of up to 3 years in prison. Additionally, Article 226 stipulates that anyone found guilty of deliberately and publicly promoting indecency can face 6 months imprisonment and a fine. The initial Tunisian Penal Code dates back to 1913, the time in which Tunisia was a French protectorate, and the Penal Code clearly originates from the French Penal Code of 1810 in terms of its structure. But the document also acknowledges that the importance of and incorporates aspects of Sharia and Tunisian jurisprudence. However, the French Penal Code, unlike the blueprint penal codes which traveled through the former British colonies, did not include criminalization of so-called sodomy. Equally, former versions of the Tunisian penal laws, for example, the 1861 Tunisian Penal Code, did not include regulations on sodomy or mention homosexuality explicitly. So this raises the question of why and how this provision was in the end included into the Tunisian Penal Code at that time. It's really difficult to reconstruct the developments, but what is clear that at some point there was a handwritten comment on a printed draft proposal, and this comment made it into the final version. and this final version exists until today. So, today, these penal code provisions, 230 and 226, as well as variations of similar provisions in other countries around the world, remain in effect. In different settings, these provisions are exploited and used or misused by institutions and individuals to further scapegoat LGBTIQ+ individuals as part of flourishing anti-rights agendas that we currently can see all over the world. Especially governments pursuing such an agenda tend to follow similar strategies. Among others, limiting access to healthcare for LGBTIQ+ individuals, restricting or censoring media and public discourse on this topic, intimidating or harassing activists, and a very special one that we know from many countries, denying official registration to NGOs, for example, also in Kenya. So Tunisia is no exception to any of these. And in the following, I will highlight a number of examples. And just a small hint and reminder, please see these examples also in the context of Tunisia's political and legal landscape. So especially the 2011 revolution, as well as the new constitutions of 2014, with providing a number of robust protections for fundamental rights, and the constitution of 2022, which introduced yet another shift to weakening checks and balances. So in 2015, the then Minister of Justice suggested that Tunisia should work towards decriminalization. However, the Tunisian president rejected the statement, claiming it was not in line with government policy, and consequently, the minister was dismissed later the same year. At the same time, there are national as well as international civil society organizations which are campaigning for decriminalization and the protection of SOGIESC rights in Tunisia. However, these efforts are often or always met with resistance. And perhaps the best example that we also see in other countries is the organization SHAM, which is very prominent in protecting SOGIESC rights in Tunisia. And after this organization has been registered legally in 2015, the Tunisian government attempted to revoke its legal registration. As I mentioned, a very well-known scenario in different places. The government claimed that its work violated Tunisian society's values and was not in line with its penal code. One of the main arguments that governments bring forward. However, in 2020, the Court of First Instance initially suspended the activities of the organization SHAMS for 1 month, but later reversed its own decision. The Court of Appeal ruled in favor of SHAMS, responding to an appeal being filed against the reversal of the Court of First Instance. So the Court of Appeal stated that the government had no legal grounds to shut the organization down, and in the end granted SHAMS permanent legal protection. Huili and Livine-Spound compile in their report on Article 230 instances of arrests, anal examination, social marginalization, sexual violence, psychological trauma, and discrimination under the color of law. Alongside other scholars who have explored the aftermath of the Arab Spring, particularly concerning SOGIESC rights, they describe post-revolution Tunisia as a strange legal reality, where courts and police continue to enforce a wide range of laws and legal codes that clearly contravene the new constitution. The new constitution, they still mean the 2014 constitution, which is now not in place anymore. Yeah, okay. And now, in the past years, a number of additional examples have happened. And especially trans people have been at the front of government practices. So, for example, in 2023, Tunisian police officers reportedly raided the home of 3 trans women. And this is just one example out of many that we have seen over the past 2 to 3 years. And I find these examples deeply worrisome They highlight developments and consequences around criminalization of same-sex sexual activities in Tunisia, not only for LGBTIQ+ individuals, but for everyone that is in support of these rights. The domestic frameworks and policies do not sufficiently account for the regional and international standards set for the protection and promotion of human and people's rights. And while having highlighted Tunisian specific contexts now, the observations align with troubling broader trends of increasing hate crimes and marginalization against LGBTIQ+ individuals on the African continent, but also beyond. And in my last 4 minutes, I would now like to share some thoughts of what we can learn for and take over to law and belonging. So I asked myself, what can we learn from SOGIESC rights and this case study from Tunisia for belonging? What is a possible contribution to the conversation of law and belonging for LGBTIQ+ people and beyond? In this context, I have identified 3 realizations as well as 4 propositions with which I would like to close. So first of all, laws can shape one's sense of belonging to one's home country by creating a negative delineation, particularly when it affects one's personal decisions and human dignity. Secondly, while law wants to give the impression of neutrality and being unpolitical, this experience demonstrates that law is hardly neutral. In fact, the conversation with B exemplifies how laws can profoundly shape one's sense of belonging to one's home country. But B's story is not unique. People all over the world experience similar realities. For LGBTIQ+ individuals, legal restrictions, for example, their choice of sexual partner, can lead to feelings of alienation and exclusion, as they may feel unable to live openly in their own society. And their right to choose is fundamental to their personhood and core to the essence of being human. And consequently, any restriction on the ability to freely choose one's sexual partner also limits one's human dignity. And thirdly, legal principles are used and misused to force exclusion, power imbalances, and scapegoating, for example, in the context of SOGIESC rights in Tunisia, and thereby undermine the concept of belonging. And this raises then again a number of questions. What are the emotional and psychological dimensions of belonging, and how are these shaped by legal processes? And is the law enough to change one's sense of belonging? And I want to close with some propositions that I'm still thinking about and that I would like to do some more research on, and that maybe you also can help me think through. So firstly, I propose that the relationship one develops with one's home country can have varying effects. Desire and activism to change the country itself and its legal frameworks for the better, as seen from the perspective of the person affected, or lead to withdrawal from the home country's affairs, sometimes even resulting in relocation, something that B is considering. This withdrawal has consequences, such as failing to fulfill one's individual duties as outlined in the African Charter. However, as Sarah Reid and I have argued, it is first and foremost the state's responsibility to create conditions that enable citizens to actively fulfill their duties. This is not given when LGBTIQ+ individuals are marginalized and drawn to the outskirts of society. Secondly, I want to argue that criminalization of same-sex sexual activities can falsely, nevertheless effectively, also foster a positive sense of belonging in individuals towards their country. This proposition is closely tied to the anti-rights movements we are witnessing globally, which often misuse SOGIESC rights as a common rallying point. Thirdly, these experiences suggest that the law's effect on one's sense of belonging is particularly evident when strong interpersonal relationships are disrupted and intimate rights are violated. And then I ask, the more personal the impact of a state's action or omission, the stronger the effect of one's sense of belonging. But what can we consider as personal and intimate? Beyond SOGIESC rights, other examples from around the world and throughout different periods of time could support this proposition, including abortion laws, apartheid in South Africa, marriage structures in India's caste system, and many others. And lastly, one might also argue that the more direct the state's interference and impact on an individual's rights, such as through police harassment, a court decision, or a specific law, the greater the impact on that person's sense of belonging. And the other way around, that would mean when the state's involvement is more indirect, such as through failure to protect one's rights from abuses by third parties, the effect on one's sense of belonging might be less pronounced. With these open propositions, I finish and I look forward to the discussion. Thank you.
Thank you very much. Thank you. That's so fabulous. I've never been to a conference where literally every single speaker has connected to the theme, and not just as an add-on, but as actually proper engagement. So thank you very much for our four panelists. I thought they were fantastic. So I have three things written down: exclusion, equality, context, and impact. But the framework that I thought actually worked with all four of you was the Race Committee's General Comment number 25, Sir General Comment number 25, Philip, paragraph 5, check it out. And it is form, what is the form of the violation? What is the context of the violation? What are the consequences? And what are the remedies? And I think you'll see that each of them has applied this framework in terms of thinking about it. So we had migration. I think with GIFT we had gender-based violence, and actually I'll just say as a sidebar, GIFT, Malawi has literally taken your Domestic Violence Act from Part 4 of the English Family Law Act 1996, literally copy, paste, because it felt like I was teaching family law listening to you, occupation protection orders. From Dr. Krafzik, we had very interesting kind of construction of the form of the violation, which was kind of macro structural inequalities, you know, as grounded in institutions. And from Isabelle, obviously, we've had, you know, SOGIESC. So that was my way of thinking about it. But we've got 35 minutes, and so we're going to open it up to you. So let's take the first round of questions or brief comments, using me as an example of what not to do.
Thank you very much, Farida. Thank you very much for a very good presentation. I will ask the questions in the order of the program that I have here. To Nelson, I was just wondering, and this is a word thought, on whether you are more interested at the more higher abstract level thinking about the sites of belonging, especially the relationship between the virtual sites where the registrations take place, then you have the physical sites, where you have all these kind of, you mentioned 23 or 24 services that are accessed. I mean, what is their relationship and how do they remain in place, or are they instruments of power? I'm thinking about sorry, I'm a very big theoretical fan. I'm thinking of governmentality, the Foucauldian idea, but it's a word thought. But the material that you presented led me in that direction of thinking. For GIFT, fortunately, Farida has done some background work for you. Pointed out the source of this legislation. I'm just wondering on how we can avoid the trouble walking in the footprints of the colonialists. What would you propose as a way in which we reflect on the social realities when coming up with the legislation? On Sebastian, thank you very much as well for a very good presentation. What I was wondering is whether you have considered how ideas play a central role in maintaining the hegemony of the World Bank. You mentioned the market efficiency, market assumptions. How do these sustain? Because that hegemony has lasted for a bit of time. And I was wondering whether those ideas have any role in sustaining the hegemony. And to Isabelle, You made a very interesting statement about the lack of neutrality of law. I mean, half the lawyers probably wouldn't agree with you because that's like dogma. The law is neutral and objective. But I just wanted to maybe hear a little more on how you disapprove the objectivity and neutrality of law. Thank you.
Thanks very much, appreciated. Anybody else want to have a go or add? No? Okay, why don't we get going with those? So one for everyone. Oh, so was that your hand or no? No. Okay. Shall we start in the order in which the questions came? So Nelson, please.
Yes, thanks for the question. I would like to respond by saying that as part of the approach that I'll be taking in the analysis and written this down as I was brainstorming on this, I was looking at this because I'm really concerned about the point when an injustice is cemented through a digital system. So it means that there's an injustice that has been ongoing, and from those experiences I mentioned to you, that it's because the government is not providing enough, essential services. That's already an injustice, and when it causes these communities that live in the localities of the refugee camps now to register, that is already an injustice. But I'm really concerned about how this injustice can now be cemented when you are introducing digital ID system, in which case any person who doesn't have an ID now is not able to have access. In terms of the approach that I would like to take is to see how we have direct effects, direct impact, and how that direct impact also leads to other intersectional impacts, especially on other rights that are hinged on the right to nationality, and how that can also be exacerbated by the introduction of the digital systems, and in this case, the system for capturing the data for the refugees, at the same time as the system for that is used for the implementation of digital ID. So I see this in a graduated format of analyzing, but in terms of the theoretical lens, the lens of looking at this, and I remember in the preparation of notes, I feel that this is an abnormality that has been happening. And in mostly, for those introducing the digital technologies, they will not be really aware of what has been happening to the locals in the Northeastern. So I'm seeing an abnormality, and as an abnormal situation, I feel that Fraser's abnormal justice provides a very, very good critical lens to not only understanding this impact, but also in terms of imagining how they can be resolved.
Thanks, Gift. I think you're next. Do you know your question?
Yes, I do.
Okay, I wrote it down.
Yeah, thank you, Cyprian, for the question. I think how do we avoid walking into the same trap? The first one would be to look at what are the values that are in our community. What is the community saying? What is the socioeconomic situation in the country? If we look at that, the possibility of laws addressing that, addressing the needs of the people and their realities is very high, other than just looking at what other countries are doing and trying to implement. I remember when the PDVA Act was being drafted and being presented as a bill, there was a verge of domestic violence in Malawi, and the NGOs were very much to the government. They put pressure to the government to put in laws that are there. And this act was enacted before the Gender Equality Act itself. So there was an haphazard way of bringing in the law. So my suggestion would be, it doesn't have to be very haphazard as that, lest we just copy what is somewhere else and claim it as our own. So those are my ideas at the moment.
Sebastian, if I may, Dr. Krafzik.
I go with Sebastian. Thank you. That's cool. Just the question that I understood your question correctly, it's about why does the system still exist like this, right?
Yes, I think that the right question is how.
Okay, cool. Yeah,
The hegemony of the World Bank.
cool. Yeah, this is a question when I teach law of international financial institutions, so it's not only the World Bank, also the IMF. This question always comes up by the students, and it doesn't matter where, here in the global South, but also in the global North, because we all can feel this is kind of, yeah, injustice. But then how could we change the system? How can we change the World Bank or the IMF? I mean, someone needs to give away power, share power, but who wants to share power? So it's about the global North and especially the United States with its veto right. I don't think that World Bank and IMF will be possible to change in itself. Especially with the current American government, I don't think they like to share more power. So they actually will even more use their veto right within the World Bank. But the same applies to the IMF, by the way. My idea, but I share this idea with a lot of scholars. We have to come up with own ideas within the global South, and yeah, here we go. We have those South-Southern corporations. We have the African Development Bank. Still, also South-Southern corporations. They depend on money from donors, and the donors are most of the time in the global North. And still, we are making progress. We see that the voices of the global South are more and more heard, and platforms like G20, first time South Africa, first time an African country has a presidency over G20 this year. So those are platforms the global South and especially Africa can actually make itself hearable, can actually come up and speak out loud. Thank you.
Thank you very much, Sebastian. Isabelle.
Okay, thank you very much for your question, Sebastian. So quite big and large question, but I will share some of the thoughts I have. So I think, first of all, we have to ask ourselves what is neutrality, and what would legitimize law as being neutral. So there are different steps of how law is developed and different ways of how law is applied, right? And I would argue that at each of these steps, we have people being involved, and that already makes them not possibly neutral. And we talked a lot in these days about this relationship between the people, society, and the law. And I think as soon as we accept that the law is made for the people and not the other way around, we already say that law cannot be neutral. Personally, I see law as a tool. It can be used in positive ways to ensure the protection of human rights, for example. And then there are also individuals and institutions that misuse law, as I have tried to illustrate on the example of SOGIESC. And when I continue in this area, I have followed a little bit the developments in different African countries that are trying to establish new laws on anti-homosexuality. So looking at Uganda, Ghana, also discussions in Kenya. And I think they are the best examples of how laws are not neutral. So we see a strong political as well as religious influence, and we see purposes of why these laws are discussed and try to be established. So let's look at Ghana, for example, that has really been in difficult times, financial difficult times, political difficult times, and the discussions and attempts to incorporate a new law on anti-homosexuality is, for me, an attempt to bring people together on board to find one scapegoat and ignore or forget other issues. So I I think that's all I can say for now. I guess there are a number of examples where it's really obvious that that law is not neutral. When we look at abortion laws, for example, in different settings around the world, and yeah, I could go on, but I think there are very good examples that show that law is not neutral, and it's okay that maybe half of the lawyers do not accept that or do not follow, but I think that all that we are here, we do accept that. Thank you.
Great, thank you, those are great. Next round, yes, please. So we'll go with you first, please. Sorry, I don't know your name.
Alexander, thanks a lot for a great panel. I stand up so that I can see the panelists. I would have so many questions.
Sorry, I'm here.
No, I know you're there. Can you hear the questioner?
I can hear you very well. Thank you.
Thank you.
Oh, nice technology. I would use the reverse order and try to really stick to questions. Isabelle, as a political scientist, I'm not so far from thinking about the law as not being neutral, and I would want to ask you, what if, I mean, you said something about how the law can shape your belonging or your sense of belonging to your home country. I think that was the phrase you used. What if laws were made to shape your feeling of belonging? How would that change your analysis? Because something that lawyers, sorry, I mean, just playing the role of a political scientist here, sometimes that's missing in the debate is who actually makes the law. And the funny thing is politicians make the laws and then they seem to become neutral as soon as they are in the hands of lawyers. I'm exaggerating, but maybe you get a sense of my point. For gift, I'm just curious to what extent the literature, because I don't know that kind of literature, to what extent you find sort of suggestions in the literature or what you are thinking about processes. How could processes look like that would realize a different kind of a contextualized domestic violence act? Yeah. You said there is a lack of critical analysis, but then I see so many people here in the room and elsewhere who are discussing these kinds of topics, and I was wondering what your thoughts are about that. And a last question for Sebastian. I think, I mean, it's largely unchallenged what you said for quite a while, and I was wondering about the time factor in your analysis, and I would like to push you a little bit on what do you do with the trajectory and the reforms that have been realized over the last couple of decades within the legal framework of the World Bank, including the fact that it is still true that you have that 15% threshold, but the number of issues for which you need a 85% majority has dramatically decreased. And that was, I mean, other authors would also frame that as a success of Southern actors in the World Bank framework. I'm just curious about your take on these reform processes.
Thank you very much, appreciated. Anybody else in this round? Oh, two. Oh, three. Steroids? Yes. And then, yes.
So you start.
Oh, sorry. Sarah first.
Okay, thank you.
Ethiopia always first. Because they make the
No, it's a question for everyone, perhaps also all the lawyers, not just the panel, but the point made by Sebastian about law alienating, let me use the word, the masses. That statement is what triggers this question, but I'm always wondering, isn't law always really meant for alienating the masses? And about the neutrality question, I always think about Walter Benjamin's text about law and violence, and he's always talking about how both the making and the maintenance of law is impossible without violence. And whenever there is violence, I think the question of neutrality of the law becomes a little tricky. So just reflection, but not really necessarily looking for an answer from you.
Brilliant, thank you. Thanks very much.
Yes, my question would be for Sebastian as well. You spoke about, in the end, about the necessity of sharing power and with it the resources of countries in the North, global North. And in this debate, we often speak about the states, and the states have to share their power and the resources and all of it. And if we take the states we're addressing as democracies, I would ask whether it could be, or what importance you see in the agenda setting on the voter side in the global North, because we often speak about these state institutions, but if they really would, from one day to the other day, share the power and the resources, wouldn't this lead to disapproval from the population? Because a public budget administration always is a hot debate, and couldn't it be very important to go to do agenda setting from the global South and the global North to invest in this and convince voters this way to make this a priority? Yeah.
Thanks, brilliant, thank you. Luca.
Yes,
Sorry.
thank you. My question, the first question goes to Nelson. In the context of law belonging, law as a mediator and practice and stuff, is it possible to have that way, this way or that way, and no between, no in between? Is it a realistic expectation? The other comment or question goes to Isa. Isa, when I saw the topic, the first thing I thought is how the way we think about things, I can criticize my mother, but I can't allow you to criticize my mother. So I can say my mother is bad, but you cannot say it. If I don't know you and I saw that article, that's how I felt. I could be wrong. I would not read it. I would say this is white supremacy. It's a feeling of the right that better or something. So by writing that this is why I hate my country, and it's a Tunisian saying that. I know she said that, but have you maybe examined how that topic brings out feelings from the person who is reading it, who is an African like me, the way I felt? And did she say that as really hate the country? Sorry for saying that, you know what I mean. Or did she that to express dissatisfaction with the law, how the law makes her feel, it's making her unbelong, but she really still belongs to that space. So it's an expression of dissatisfaction. And will that topic bring out that feeling, or will it bring out a different feeling that is not hers, actually legitimate? Thank you.
Thank you for weaving in this topic into your question. Jacob?
Yes, thank you so much. The question is to Sebastian on the World Bank. As both noted, the critique is well made, and the critique, has always been there. The question is, do we need to fundamentally reform the World Bank, or do we need something else? In other words, this question of the reform of the World Bank, do we need the World Bank? I mean, some people talk about the BRICS Bank and other alternatives. What is this, holding on to the idea of a reformed World Bank, a reformed IMF, when they were created, just like international law, as we heard yesterday, created in their origin, but also in their ongoing functioning, to legitimize a global matrix of coloniality, in a sense. So do we need the World Bank? The question to the first two speakers, you seem to be saying that the way to reform the domestic laws and the other laws is by incorporating more indigenous ways of understanding the world, or customary law. I've got two questions. One, there's nothing fundamentally emancipatory about indigenous law. There's nothing fundamentally, progressive about customary law. So to what extent do we think, by reforming these laws from the perspective of indigenous law would be good for women or even good for sexual minorities, when we know that indigenous law, there's nothing inherently, I'm not saying it's inherently bad, but there's nothing inherently emancipatory about it. But also, of course, a lot of the indigenous law is based on the colonial library. It's not based on, timeless ways of doing it. It's based on the colonial library, anthropology, missionary accounts, and so forth. So when we say we need to get rid of borrowed robes for our own robes, do we even know our own robes in a sense? When, as I said, if you look at all the countries, most of what is considered indigenous law, customary law, is based on this colonial library made up of missionary, accounts, as well as anthropology. Of course, it's living customary law. Very skeptical about that, but we can also talk about that. The last question to all the speakers really is about, you have made the point very well about the non-belongingness of a lot of people, indigenous people, or women, sexual minorities. Is belonging possible in the nation state? Or is the nation state fundamentally always about the production of non-belonging, the nation state? So we are talking about a lot of, reforming the laws and so forth. But that is almost attending to the superstructure of the problem, while the base is, of course, the idea that at the heart of it, the nation state is always a violent creation about the production of the insiders, the outsiders, the others, and those who belong and those who belong. Is belongingness possible in the nation state? I'm asking you, but I'm also asking the chair. Thank you.
Thanks very much. I think that's my last round, so that's the end of Zimbabwean democracy. And so we're going to have the answers, and then we will do Philip. And I think Philip wants to say something to the students, so I'll remember. So we're going to have a last round of answers, and thank you very much for those fantastic questions and interventions. Appreciated. And panel, you've been fantastic on time, so let's keep with it. Where did we start? Sebastian, I think if you could start, I think the early interventions impacted you or were directly related to you. Initially, I think Isabelle, Gift, and Nelson.
Thank you very much. Thank you for your questions. Let me start with the question. The first question I received about ongoing reforms in the last couple of years. Sure. The World Bank made a huge progress. Also IMF. So when we talk about World Bank, we also we automatically also consider IMF. Actually, those two institutions work very close together. One is focusing on macroeconomic issues, and the other one that is IMF, and the other one, World Bank, is always looking for like financing individual projects. Both institutions made huge progress. So in two ways. First of all, they gave more money to the global south in different ways, different extra programs. Also, especially after COVID. During COVID, I used to live in the global north, so and I used to live in France. Actually, I felt I was hit by COVID, but yeah, the global south they really suffered much more. So World Bank and IMF came up with a lot of financing programs, and also they changed the way. To a certain extent, they changed their way in how they ask for conditions, especially when it comes to social and environmental issues. So there are now some frameworks World Bank and IMF follow, and this is quite important for the global south since climate change might affect the global north already, but in the global south it's much worse, especially in Africa. So, and all those projects that are going on, especially those large-scale projects, building up dams or nuclear plants, big street road projects, so they can hit the environment to a certain extent. And here, World Bank and IMF, they came up with some interesting frameworks and programs within the last couple of decades, I actually have to say. But now, is it enough? That's the question. Still, the global south depends somehow on the global north. And maybe I can just switch over to the second question, because the two connect somehow, sharing power.
Actually, we're going to finish at 1:45 because we've got a 4:00.
Oh, sure. About sharing power. Yeah, is it enough? I don't think it is enough, because the global south still depends on the global north. I mean, of course, it's money that comes from the global north, so we should, and the global north must have a saying on what's going on with its money. But here we have a bigger discussion, because then what I see in the global south, the discussions go far to the back, to history. Why is the global south financially and economically so weak? Yeah, because there was colonization. What happened after colonization? So the countries, the colonial states, they left the countries somehow empty. It's a bigger discussion. We have to, yeah, we have to do another conference on that. And the third question, the question, something instead of World Bank. I think this is the only solution we have. World Bank and IMF we can't really change because of the big players. They won't share power, which is also kind of understandable somehow. But then we need to find some alternatives. And here I think those Southern corporations, African corporations, they are still so far the best approach. Thank you.
Appreciate it. Thank you. Thank you for your brevity. Yes, Tanya?
Okay, I think I go next. Because we don't have so much time, I try to address each comment very quickly. So the first one from Alexander, thank you very much. So it's an interesting question. What if laws were made for people to belong to a country? I would argue, okay, but if we assume that, then we are already talking about laws that are non-mutual. That would be what I answer for now, and more later. Then there was a question on belonging in the nation state in general. I would like to just refer maybe to, or encourage us to think about Nyerere and what he said about Ujamaa and how we treat minorities in relation to care and communities and the duties that each individual has to fulfill. And I think it can teach us a lot about how nations must be built to include everyone and for people not to be at the outskirts of what we call a community and a family. Then I think Milka's question is a hard one. We were in Brussels last week and we just discussed a long time what a correct answer to this question is, but I will start from the back. The feeling of hate. So B had very strong feelings towards her country because this breakup was very recent, and I think she doesn't feel she still belongs to Tunisia. So I do think that the emotion was quite honest. She was also the one who said I should give this title to this paper. But if you would not read it, I think I would reconsider it. But that was, her proposal. And I think about the positionality maybe later more in the break.
Thanks, Alexander, for the question. I think I'll also be very quick about the processes. Maybe I'll only talk about how the laws and the bills go back to the people at the consolidation stage. When they have been proposed, who is involved? How are the people's views taken into consideration when formulating these laws? Because the people, the elites, are the ones that are assumably consulted that we have got this bill. What do you think should go into the actual bill at the end of the day? Critical analysis, my literature comes from some judges in Malawi, Mauluka, and another scholar, Chigawa, who said that maybe in the judgment, the judges have got a chance to feed into what the law says. So they have got a way of making the law through the judgments. So maybe through that, they should be able also to look at what the socioeconomic background of the people are saying. On Tsepo's question, nothing progressive about customary law. Borrowed lobs, I would be very proud in borrowed lobs, even though they have got patches. I will be proud in my own lobs, even though they would have patches of borrowed things. Yeah. So the pride that I would have would be, this is my law. This is what belongs to me. So that brings in the idea that at the community level, when we're engaging them, they usually say their laws say we should not do this. So their laws, they are alienating themselves from that laws, so they don't engage it with more. So that's where my point is coming in, that maybe we should use what we already have and take pride in it. If other things come, then so far so good, but let's use what we have. So short, maybe that's.
Thank you very much. Nelson?
I would like to reflect on the 3 questions really quick for Professor Tsepo. You mentioned this point on whether this is possible. I think that it is possible if we look at the fact that there are some outsiders that are intended to be outsiders because law is usually about stratification, but there are some that are not intended. So for those that are unintended, and especially for the case that I was analyzing, even the government say that they have realized that there's a problem and they're trying to solve it. So you find that there are, even in creating stratifications within society, through using the law, there are certain ones that are unintended. And the example I use about the case is how you can peel back that mask of historical injustice to try to bring it back to where it ought to be. And I think for those that are intended, I believe that the law is itself also designed in a manner that is self-reflecting, because the judges, for example, or other actors have the ability to develop the law. So the fact that it is not static maybe gives some opportunity, but whether that is optimal might be subject to discussion. For as Sarah will point on whether the law is neutral, I think I've partly answered it, given my view on it in response to the first question, but I still believe that law usually creates this stratification, but maybe that gave me a moment to reflect on what Cyprian had asked earlier. In Kenya, for instance, those who live in the northeastern part are mostly of the Somali origin, and there's usually a lot of external influence, especially from the US, regarding how Kenya should be treating persons of the Somali origin, given a lot of things that have been happening in the Gulf states. So this is also a lot of the belongingness that depends on politics and also other external influence. But regarding Milka's point on law as a mediator, I think we'll try to see this as we maybe over coffee. But I think that if you look at the judgment that I made, while the government was saying that these people are authors of their own misfortune, court actually said that they are victims of circumstances. So you can actually see that it is possible to change the narrative for courts to, or maybe other actors to reframe problems. And I think this is also something that several other actors might take moving forward.
Panel, thank you very much. I was, we absolutely held the standard that we had yesterday. So thank you very much to Nelson, to Gift, to Sebastian, and to Isabelle, and of course to you. So we're going to have a break, and don't forget, please, the people to meet Philip at the back.